All right, welcome back. This is episode 2 of our LinkedIn Live series about building an investment-ready biopharma IP portfolio. We're from EIP, which is a multinational IP law firm, and we're talking from our head office today in London. My name is Tim Belcher. I'm a partner in the chemistry and pharmaceutical group, and this is my colleague.
I'm Rob Barker. I'm a managing associate, also in the chemistry and pharma group.
And today's session is about strategic IP moves might make before investment rounds in this biopharma market. We have extensive experience supporting both the investor side and potential investee side, and we're going to talk about this topic from both angles. So I think the first thing I would say for target companies who are seeking to attract investment is to know your investors, to know what they look for, to look at their previous deals and see what they value. And that way you can tailor your IP portfolio and proposition to them. From an investor side, what is it that you think companies are looking for?
Absolutely. So to some extent, similar geographical extents of protection are important. So trying to map, if there's a certain target acquiree that you're looking at, trying to map your patent portfolio onto the countries that they're interested in can be very important, because that's where they think that the best markets for their product will be. Similarly, also trying to get early, quick protection, potentially in the US, to show that you have a valuable product that can get patent protection, can help ease any worries about being able to secure the market later on.
And I think getting a granted patent can take time is a really good idea, but therefore knowing when your investment rounds are coming up and communicating that to IP advisors early allows us to get that granted patent, that sort of cornerstone of your IP, get it in place early and really support the investment round. If an advisor is sort of in a more passive capacity, doesn't have all those business milestones, the critical milestones, the IP can trundle on quite happily, but isn't in the best condition possible to support that investment round.
And to be able to say, from the investor side, it's very helpful to have IP advisors who have a better holistic view of what the deal is going to look like, instead of just being on the sidelines and looking at one very specific part of the work, understanding what the drivers are for the acquisition, what other features might be in play. That can help give more holistic, well-rounded advice, whether it's a go or no go.
I think the other thing I would say for the sort of company attracting investment is they need to show a well-reasoned IP portfolio. They need to show we've got these assets for these reasons, and that might be sort of paired alongside a business plan and a market access report or sort of a health economics report. Show that you filed this case for this reason to give this much patent term, and it's going to be worth this much. There's a chance for an investor to recoup an investment. I think if the IP is a standalone floating asset, which isn't tied to the overall business plan, that could really put off investors.
Yeah, I think the IP has to work for the actual business case. Otherwise, it's just a cost sink that isn't giving a lot of value.
And if you're showing that the IP gives value for money, you're also giving yourself credibility in the eyes of investors, which can only help, I think. So yeah, that sort of goes to the next point I wanted to address, which is to let your IP advisor know when you're going to be hitting those investment rounds, but also let your IP advisor know everything you're going to disclose to the investors. I've seen a number of deals where business critical information has been handed over to an investor and that hasn't been protected beforehand. Now that done confidentially isn't a problem as such, but it's far better. It's better practice to get everything on file beforehand. And saying to an investor, we don't want to disclose that to you because we haven't filed on it yet, is going to make them question why. I think from the investor side, that there'd be an understanding that things must remain confidential, but they will want to know why you haven't filed on it yet. Is that fair?
Absolutely. And I think if in that situation where you're not perhaps quite ready to file on something, perhaps the science isn't quite there, having a pragmatic workaround makes everyone a lot more safe in the negotiations. For example, if you have some confidential data that shouldn't be shared more widely, perhaps you could agree a clean team on the investor side who will see certain parts of information which won't be disseminated any further. I mean, with that, it's also important to have solid confidentiality agreements explain exactly what can be shared and how, and who has access to these documents.
And I think we do quite a lot of work for clients where we're working on the behalf of the investor. We receive confidential information from the potential target company, which we're allowed to see, but we don't actually then pass on to the investor. We just give them our advice on the merits of that. So there can even be firewalls between the investor and their own advisor to protect confidentiality.
That's right. And if you've got a trusted IP advisor, even if the amount of information you can give the investor is relatively limited, they understand that good work has been carried out and that analysis and assessment does have value and can help inform a deal.
Yeah. And then just the last point sort of on business planning and attracting investors is probably when you're seeking investment rounds, you won't hit all your technical milestones. There will be more work to come and more IP planned. Having all of those mapped out against your business plan, against your clinical trials, against the scientific progression, really helps an investor understand they're not just looking at what you've already got, but what the business plan is and where to go, and how the IP is a key part of that.
And it could be that during a due diligence exercise, some unpublished patent applications might be shared, again under certain confidentiality requirements, so that the investor can see that there are plans in place and you're acting on them proactively.
Yeah. So in terms of, those are the sort of the strategic points, outward looking, and how can an investee attract that investment, prepare for it. One of the things we've done for a number of our clients is a mock due diligence exercise. So we have someone else in the team come in who might not have worked for that client or worked on their portfolio and go through it and assess that everything is ready and investment ready. It allows us to identify any points where we can strengthen the position. And it gives our client the comfort that everything has been done, everything's been looked at with multiple pairs of eyes, and that really everything is in place.
So as a person doing a mock due diligence, what sorts of aspects would you be really trying to focus on to work out whether it's investment ready?
I'd be looking at whether the patent protection that's been drafted is in good order. Have they protected the crown jewels, the lead asset? Have they got a granted patent on that, or can we get one in place sooner than the investment round comes about? I'd also want to be looking at agreements. I'd want to know that all IP ownership is undisputable, or an investor is going to want to be certain that the rights they're investing in are owned by the company they're investing in. So I'd want to make sure that all the agreements are in place and everything is clean on that front. I'd also want to see what the future filing plans are and peg those against what data has been generated and what data is planned. The last aspect I think I'd be looking at is freedom to operate. And if any investor worth partnering with will want to know about freedom to operate and will most likely perform their own review on that. Freedom to operate is a task which should be repeated throughout the product development life cycle. Early reviews, when the details of the asset might not be fully settled, will be more like a landscape review to identify any big blockers. But I think as approaching investment round, an updated freedom to operate that is more robust would also add a lot of value. Some schools of thought say don't touch freedom to operate. It's better not to know what's there, and then you don't have to disclose it to investors. I don't think that applies in this technical sector. Investors are going to do that review, and if you haven't done it, investors will be concerned and want to know why. I also think it's better to know if there are skeletons in the closet, know what they are, where they are, and how you're going to tackle them. I think on the investor side, freedom to operate is a big part of what we're doing.
Yeah, it's a huge thing that they need to take into account. And whilst in the perfect world, there'll be no blockers, no problems whatsoever, in reality, there might be certain issues that have to be mitigated. But if, as someone to be invested in, can be proactive in that and say, I'm aware of these problems and these are how we're going to address them, That adds a lot more confidence to the deal. And one, recognizes that they're taking IP seriously, and two, that they've got a thought out process to make sure that their asset can get to market safely.
Great. And then I think the last thing on our talking points for today was data rooms, which I think you probably had more exposure to with some of the deals you've supported.
Yeah. So putting together a data room, not only just for the IP, but for everything that needs to be considered as part of a negotiation, is quite a big job. So trying to do all that at the last minute, just before a very important negotiation, is going to be very stressful and probably not very useful for anyone involved. So I think it's an easy starting point, adding to a virtual data room as time progresses, as more data becomes available, as more rights are generated, makes the whole process a lot simpler, a lot safer. It also means you've got an oven-ready thing you can hand over to an investor and say, here you go. Also, having it set up in a logical, sensible way means that investors can find the information they're looking for quickly and efficiently. Also means that you can potentially allow access to only certain aspects for certain people. For example, if there's a clean team at the investor side, perhaps they can only see certain parts of the data room. If that's all been created organically from the ground up to start with, it's a lot easier to do that than rushing around at the end trying to make it work.
And certainly on the investee side, a data room is a very easy way to allow communication between our clients and the IP attorneys, who allow us to see what's going on when, and proactively advise as and when things come around.
And these deals are often quite time sensitive and compressed in timelines. So making sure that the information is there, ready, available as and when it's needed, rather than potentially having to have delays built in by not being able to put your hands on the right document, could seriously affect a deal that might be on the cards.
And I think with the increasing move towards using CROs and teams that are sort of global teams all over the world, if an investment deal is time critical, having everything already there is great, rather than having to go to a Chinese partner and locate a document and then get it translated and then go to a American partner, for example. I think building it as you go along just makes life a lot easier. So I think that was essentially everything we wanted to talk about for today's session. I hope it was interesting and maybe learned a few things. Join us next time, where we'll be looking ahead to 2026.